Hello everyone, welcome to Pahuja Law Academy. My name is Anurag Singh and today we'll be studying about the Arbitration and Conciliation Act of 1996. Right. Now this is a very important act, not only from a practical point of view because more and more cases are going for arbitration, that is the out of court settlement, but also from an examination point of view, right? Because in Delhi mains and prelims, both, you will have to answer questions from the Arbitration and Conciliation Act 1996. Earlier it was the principles of arbitration law, but recently the syllabus has been changed and the Arbitration and Conciliation Act of 1996 is also now included in the syllabus, right? So it becomes immediately important, and also in states like Bihar you have to study, and there are other states also where Arbitration and Conciliation Act is one of the main subjects. This is a very important act but often ignored, right? People do not give due and proper attention to it that it must be given to, right? So the Arbitration and Conciliation Act is important not only from a practical point of view but also from an examination point of view, right? So before we go into the Arbitration and Conciliation Act, first we need to understand why do we need an Arbitration and Conciliation Act, right? Now, first we need to understand the meaning of ADR, right? What is an ADR? ADR stands for Alternative Dispute Resolution. Right? So ADR stands for Alternative Dispute Resolution. But what, as an alternative to what? As an alternative to the ordinary court procedure. Ordinary court procedure. Right? So ADR is what? It is an alternative to dispute resolution, and the alternative to what? It is the alternative to the ordinary court procedure. Because even in courts, why do you go to a court? We go for dispute resolution. When two parties are disputing the same things, one is saying this is mine and the other is saying this is not mine, or saying this is not yours, this is mine. Both parties are equally contending the same thing. There a dispute arises, and it is at that moment that they approach the court for the resolution of the dispute, right? So alternative dispute resolution is an alternative to the ordinary court procedure. That is the first thing you need to keep in mind, right? Now, but why do we need this alternative, right? That is the ordinary court procedure not sufficient? Is it not able to give proper remedies in a case? Is that the reason that we need an alternative to the court procedure? There can be many reasons why do we need an ADR, right? So the need for ADR, what are those, right? Now the first would be that the civil courts, they are already overburdened. They are already overburdened with the pending cases. So as you know, in our judicial system, it is not very smooth, and the thousands or lakhs and crores of cases have been pending in the courts. That is why they are already overburdened with pending cases, and if more and more litigation comes up, the courts are going to crumble. So the first need for ADR is not every matter needs to be brought to the courts. Why? Because of the pending litigation, right? The pending litigation is happening there, and you don't need another set of litigation to go directly in the court, right? To save the court's time and also the time of the parties, because if the court is laden with too many cases, it cannot function properly. It is already not functioning properly, and if more and more cases come piling up, that would be the maxim, as we say, that justice delayed is justice denied. So there will be a delay in justice because of the sheer number of the pending cases, right? That is the first thing for the need of ADR. First, the courts are already burdened. Second would be the long and protracted complicated procedure of the courts. Right? See, CPC is very complicated, right? And many people do find it complicated because it is complicated, and the rights and liabilities of the parties in CPC, they are because CPC has not been made in one day. It's not like the legislatures thought that we should have a code of civil procedure and then just made it. No, CPC is the result of a long history of litigation, right? Procedural law is as much important as substantive law. So because it has a long evolution and it has come through many steps and many phases, that is why it has become very complicated, and it's very complicated, it's very long, and that is why it is very protracted. So the parties, they have to spend a lot of time in litigation. They have to spend a lot of time in litigation, right? Now, this is linked to point number 1, because there are already pending cases, so no more new cases should go to the courts. And why are those cases pending? It is because of the complications of the court procedure, that is CPC or CRPC evidence. It can be anything, but here we are talking about, since about civil cases, that is why we only need to mention about CPC. This is the only point of discussion that we are going to need here, right? Not CRPC, not evidence. So a lot of time is spent in the litigation, which is not at all healthy for the courts, neither the parties. No one is interested in a long and protracted litigation. That was the point number 2. Point number 3 is the technicality of the subject matter. Point number 3 is the technicality of the subject matter. Right? Now, there will be subject matters which are not suitable for a civil, for adjudication by a civil court. Like, let's say we have the Indian Space Research Organization. Let's say it has a contract with any other company for launching some satellites. Right? Now, there are some problems in those contracts, like कि कौन सा spectrum use होगा, Q band है, S band है, कौन सा spectrum use होगा. And that litigation, if there is a dispute in that case, an ordinary civil court is not going to be a very healthy or a very appropriate forum for dispute resolution, right? The subject matter is technical in that, like we took the example of space, and in that too, हम लोगों ने देखा, it is the spectrum which needs to be understood. Now, this we cannot expect from a civil court, that a civil court will have the technical know-how or understanding of these jargons, that is the space jargons. हम लोग civil court को ये knowledge नहीं होगी कि कौन सा use होना चाहिए spectrum वहाँ पर, S band होगा, Q band होगा, it can be anything. So just the sheer technicality of the subject matter will not be sufficient for a civil court to try the suit. There you need an expert in that area. You will need an expert in that area who actually understands what is a spectrum, what kind of spectrum is needed, and also what kind of dispute it is, and in whose decision, in whose favor the decision should be made. So only an expert in that area can know this, right? This was one example. Let's take another example, like in cases of medical negligence. Now suppose there is a doctor who botched an operation. Okay? Now instead of cutting one nerve, let's say, just for the sake of this example, instead of cutting one nerve, he cut the other one, right? And the patient, he died or suffered injuries, let's say. Now this doctor, the botched operation, what was the actual procedure that should have been followed, right? Or what was done by this doctor, but what was actually done, right? This thing, it cannot be answered by anyone who is not from a medical fraternity, right? A doctor who is a senior doctor, who is also a surgeon, must be in a very comfortable position to determine what was the actual procedure, but what was actually done by the doctor. Now that doctor, the senior doctor, will be in a position to determine what went wrong and who did this wrong, right? He will be in the position to determine whose mistake was it, kiski galti thi, was it the doctor who was at fault, or was it the nurse who gave the wrong recommendation? Maybe it can be anything, right? So that senior doctor will be the best person to determine what should be actually done in the case and what is the damage thereby caused. What is the damage caused, right? Is it a long-term damage or is it a short-term damage? Can it be cured by medicine, or does he have to need therapy? Is he going to need medication for his entire life? Now, what kind of adjudication that is going to be? This should not be done by a person of civil code. A civil judge will not have the technical know-how of what should actually be done here, what was done here, and what are the implications or the ramifications of such a situation, right? So this senior doctor is much more comfortable to be in a position of adjudication, right? So his adjudication must be taken, or his opinion must be there in order to determine what actually happened there, right? So in this case, it is not like we should approach the civil court. We should actually approach a person who is an expert in that area. So my point is, technicality of the subject matter alone is such a thing which can tell you that a person who is not an expert in this area should not have adjudicated about this dispute, right? That is the third point. Now, number 4 point is the high costs of litigation. High costs of litigation, right? Now, till now we have only covered the litigation in a civil judge's court, but that is not where the litigation ends, right? Because you do have an option of going into appeal, first appeal, second appeal, final appeal, or you can also go in for revision, review. There are n number of legal remedies available to a person, right? It's not like the civil judge has given his decision and that becomes binding. Although it will be deemed binding, but the parties do have a right to go into a higher court for appealing that matter. Now, whenever from a civil judge an appeal goes to the high court, right, immediately the costs of litigation also go very high, because the advocates practicing in the high court, they will have a very high fee, right? They do have a very high fee, and that is why high cost of litigation, this will be one of the factors why we should not go to a court for the resolution of a dispute. Because and let's say after the high court you have to go to the Supreme Court, where cost of litigation is much more higher. वहां पर भी high court से ज्यादा ही आपको मिलते हैं, the cost of litigation जो है वहां पर उससे ज्यादा ही मिलेगा, उससे कम तो नहीं होगा. right? So this is also a very big factor in the that ordinary court procedure must not be adopted due to the high cost of litigation involved in it. Now, number five is an adjudication from a stranger. Now, see, a judge, however good he or she may be, maybe he or she is very learned and has a very good grasp of the subject matter, but still in certain disputes, like in matrimonial disputes or in family disputes, let's say the property is being divided in between the family members, any person who adjudicates it will be a stranger, right? They cannot belong to the same family. They will be an outsider, right? So that person, whoever is adjudicating, there will always be a sense of reluctance, right? The parties, they will think, who is this person? Why is he interfering in our family affairs? Although they will have to abide by the court's decision, but they will always think that this person is not one of our own. If a person to which both the sides in the families they trust, and they also know that this person is going to give us justice, right? That person would be much more trustworthy in the eyes of the parties. The parties will be willing to accept his decision more readily, right? So in arbitration, what happens? The parties themselves choose the adjudicator. Okay? So here the award or the decision that comes in is not by a stranger, right? Is not by someone who is unknown to the parties. No, he is a person who was chosen by the parties. That is why the acceptance or the willingness of the parties to accept the award is much more higher in the case of an adjudication done by a person who is chosen by the parties, because the civil judge who presides over the court proceedings is not chosen by the parties. You cannot go to the court and say, I don't like you, you are a stranger. I will only go to a court which I know कि ये जज को मैं जानता हूं, तो मैं इसी कोर्ट में अपना केस लड़ना चाहता हूं. No, it's not going to happen. That is not going to happen. You will have to fight it out in that very court, and you will have to actually abide by the decision of that court, even if you don't like it. Even if you don't like the judge, he or she, you will have to abide by that decision. There will always be a sense of reluctance in accepting that decision. But if the parties have themselves chosen the adjudicator, there will be a higher chance of accepting his or her decision, right? Now, after this is point number 5, which was that an adjudication from a stranger. Now, number 6 is continuation of relationship. Right? Now, देखो, if a case is sent to a civil court and the civil court gives a decision, in most of the cases, what is going to happen? There will be a winning party and there is going to be a losing party, right? In most cases, not in all cases, because the parties may enter into a compromise under Order 23, Rule 3, a compromise decree can also be passed. But in most cases, there will be a winning party and a losing party. Like, let's say in a matrimonial case, right? Let's say there is a matrimonial case, or you can take also any family dispute, let's say property dispute between co-partners. देखो, co-partners, let's say there is a big family property, बड़ा सा घर था, and the co-partners, they have filed for a partition suit, right? They could not agree with each other. That is why they came to the court and they want to file a suit for the division of the property. Now, when the property is divided, it's not like you can just take the property and move away. No, you will have to live with them. They will be like your next door neighbors always, and that is going to be always the case, right? अगर एक प्रॉपर्टी डिवाइड हो गई है, that does not mean कि you don't know each other. नहीं, you will still be there living next to each other, and since you have been family and you had litigation with each other, that soreness जो जिसे कहते हैं रिश्तों में खटास आ जाती है, वो एक बार आ गई, it is not going to go away very easily, and you have to live with each other. You have to live with next to each other, maybe even on the same floor. अगर हो सकता है फ्लोर आपका डिवाइड कर दिया गया हो, if the right side of the floor is yours and the left side of the floor is yours, right? ये काम भी कर सकते हैं ऐसे. So in that cases, although the property has been divided, but it is better that the relationship must continue, like they still behave as family, right? Because you cannot choose your family and you also cannot choose your neighbors. आपके neighbors आप नहीं choose कर सकते. Whoever they are, you have to live with them. And that continuation of relationship is very important for the peaceful enjoyment of your property. मान लो कि अगर आपको प्रॉपर्टी मिल गई है, but your neighbor keeps pestering you all the time, आपको परेशान करता रहता है, your right to peaceful enjoyment of the property will be hindered each and every day. Now that happens when the court gives the decision on legal principles only. देखो, if the court has given the decision on legal principles only, the court is not going to look at what is going to happen after that. Are you giving them more and more grounds for litigation? Because if there is nuisance created, you will go and file a suit again. That is a multiplicity of proceeding. But this all can be avoided by appointing a person who understands the family dynamics and who also understands that neighbors and family members, they should have a continued relationship. They cannot live away from each other. They have to live together. That is why he can bring them to such a decision or such a merit that is agreeable to both sides. He will give the decision, the person who has given the decision, he will give the decision not only from a legal principle point of view, he will also give it from a practical point of view, that it does not hinder your right to peaceful enjoyment of that property. But the court will give the decision based solely on the legal principles. The court is bound by the law. It is also bound by the precedents of the Supreme Court and the High Court to which it is subordinate, and that is why the court is not going to look at this कि neighbors के साथ या family members के साथ ये रह पाएगा या नहीं रह पाएगा, is he the one causing problems or someone else is going to cause him or her problems. वहां के लिए देखो, there will be certain disputes. All I am saying is there will be certain disputes that even after the resolution of the dispute, the relationship must continue, and in that case it's not the court which is adequately equipped to actually give that decision. It is a person whom both parties trust, and they trust him to give the right decision which is equally acceptable to both parties. So the continuation of relationship is another reason why the dispute must not be sent to a court, and it must actually be sent to a person who is acceptable to both the parties, right? That was point number 6. Now see, ADR, we have discussed point number 6, and I think these are sufficient for understanding why do we need ADR. We don't need courts in these cases, we need ADR. If you want, we can take one more example. Let's say there is a dispute between the management of the company and the labor union. Right? Now, if they go into litigation, right, the court is going to give decision in favor of one or the other, right? That is going to happen in most of the cases. Not all, I am saying this again, not all, but in most of the cases, the court is going to give the decision in one of the favors of, the court is going to give the decision in favor of one of the parties, right? Either it is going to be the management of the company or it is going to be the labor union, either one of them. Now, if the management wins, the labor union will try to what? Hinder the working of the management. They have lost, and that is why they would like to find each and every small thing which is actually going to annoy the management. Vice versa, let's say if the labor union won, the management will try to create each and every problem for the labor union as much as it can, right? Now, they have to work together. The labor union as well as the management community, they have to work together. They cannot work in isolation, right? दोनों को साथ में ही काम करना है. Even after the resolution of the dispute, there should be a continued relationship between these two, because according to the nature of the relationship, they have to. They cannot work. They cannot work in antagonism of each other. No, वो नहीं हो सकता. That is just not possible. It is for the healthy working of the company or the institution they are working for. They have to work together. So there should be a continued relationship between these two. तो अगर ऐसा होता है, if this happens, what is going to happen is there should be a continued relationship. And because they know that there should be a continued relationship, that is why a person who is actually very comfortable, who understands the nuances and who understands that they have to actually continue working with each other, he can give a decision which is acceptable to both parties, right? So these type of, not only upon the legal principles, he can also give upon the practical aspect, how are you going to cooperate further, right? So these are the reasons why we need ADR, right? Now ADR is a broader concept. We saw that ADR is a broader concept, right? Now, देखो, in ADR, there can be mainly 4 kinds of ADR. There can be other kinds like mediation, lok adalat, n number of, but we have to divide it mainly into 4 kinds. Number one is, and the most important one is arbitration. This is the number 1. Number 2 is conciliation. Number 3 is mediation, and sometimes mediation through lok adalat also. Through lok adalat. And lastly, we have the judicial settlement. Right? Sometimes what happens is, this term judicial settlement is not considered, and in place of judicial settlement, actually we have to, well, that would have been more appropriate, that is negotiation, right? So these are the 4 kinds of ADR, and I'm saying this again, these are not the only 4 kinds of ADR. Lok adalat can also be separate one. There are n number of alternative dispute resolution, right? But these are the 4 main kinds that we have to consider. One is the arbitration, and second is conciliation, third mediation and negotiation, right? Now, first, one thing you should always remember, that in these 4 kinds of alternative dispute resolution, arbitration is the only one which is deemed as an adjudicatory process. It is only one which is an adjudicatory process. Conciliation, mediation and negotiation, these are known as non-adjudicatory process. Non-adjudicatory processes. Right? You need to remember this, that in all this, in all the 4 kinds of processes, it is only the arbitration that is an adjudicatory process. Conciliation, mediation and negotiation are not known as adjudicatory processes. Now, what do you actually mean when you say adjudicatory and non-adjudicatory? Right? Adjudicatory process, this essentially means there will be a binding decision. Wait, no, let's not start like this. There will be a determination of the rights and liabilities of the parties which will have a binding effect, right? So what do you mean by an adjudicatory process? An adjudicatory process happens when there is a determination of the rights and liabilities of the parties which have a binding effect. That is an adjudicatory process, and it happens only in arbitration. It does not happen anywhere else. Na hi conciliation, na mediation, na hi negotiation. None of those are adjudicatory process. It is only arbitration which is an adjudicatory process. You should always keep in mind, first thing. Chalo. So, first thing about the types of ADR, there can be mainly 4, in which one is the adjudicatory process and the other are non-adjudicatory processes. So what actually happens, we know in an adjudicatory process what happens is there is a determination of the rights and liabilities of the parties which are binding upon them. What happens in a non-adjudicatory process? Here what happens is to bring about a settlement between the parties. Okay. So here there is no right and liability which is adjudicated by the court. No, the court wants, sorry, not the court, that is the wrong nomenclature. The court does, there is no adjudication here. There is no person telling them who is right and who is wrong. No, that is not the case here. Here the person actually tries, the parties talk to each other, they understand what is going through each other's viewpoints, and then come to a conclusion ki what should we do, how are we going to proceed. Not every case must have a winner and a loser, right? हर एक केस का एक winner एक loser नहीं होना चाहिए. Like in a broken marriage, if the divorce is granted, no one is the winner or loser here. No, if looking at it, both are losers. The husband and the wife both are losers in that case, right? So if it is possible, not every marriage needs to continue. If it is possible, there should be a settlement between the parties, because see, a broken family cannot be healthy for the children, right? बच्चों के लिए, for their upbringing, it is not going to be healthy. So it is better if the husband and wife, they stay together for the sake of the children at least, and they enter into a settlement, and that is actually a conciliatory or a mediation or a negotiatory process, right? Like in mediation centers, what happens is husband and wife are not granted divorce immediately. No, they are first sent for counseling. That counseling, the conciliation process is taken, the mediation process is also taken, and then what happens is they enter into a settlement, which, so यहाँ पर there is no decision made by anyone. There is no decision given by anyone. What happens is both parties come to an agreement. They talk to each other. The person who is appointed, he helps them come to a settlement, and then the settlement agreement is what is actually agreed by the parties, right? Chalo. So याद रखना कि in all the four ADRs, it is arbitration only which is an adjudicatory process. Conciliation, mediation, and negotiation, they are non-adjudicatory processes, right? Chalo. Next we go. Chalo. Now, coming again to the ADR, 4 types of ADR, that is arbitration, conciliation, then we have mediation, and then negotiation. Right? So we have 4 types of ADR. Now, in the Arbitration Act that we have to study, the 1996 Act, it only covers arbitration and conciliation. These two are regulated by the Arbitration and Conciliation Act of 1996. Right? So the Arbitration and Conciliation Act of 1996, these two are regulated by this act. Mediation and negotiation, these are regulated by different acts, especially mediation through Lok Adalat. If it is Lok Adalat, this is regulated by the Legal Services Authorities Act of 1987. Right? So we don't need to go into these. All we have to do is arbitration and conciliation. Right? So let's start with arbitration and conciliation. Under the act, arbitration, right? The word arbitration has not been defined. Yaad rakhna, Arbitration and Conciliation Act of 1996, right? So arbitration has not been defined in this act. Now, what do you actually mean by arbitration? Right? So the act does not define it. It has been defined by judges and authors, but there is no one precise definition of arbitration. But there is a case law of Collins versus Collins, in which a definition of arbitration was given for the first time, right? So arbitration there was defined as reference of the dispute to a stranger or third party. Reference of a dispute to a third party for its resolution. Right? This was the first time that an arbitration was defined. Not a very good definition. This is a very basic definition, very rudimentary. But this was the first time it was actually attempted to define what is arbitration. Right? Now, देखो, arbitration in the act, so just to give you an overview, the act does not only deal with domestic arbitration. The act deals with domestic as well as international arbitration. It deals with domestic arbitration and it also deals with international arbitration. Right? So it deals with domestic arbitration as well as international arbitration. Now, one thing the sections, this is section 2 to 43, which is in domestic arbitration, and international arbitration, this can be actually divided into 2 parts, that is Geneva Accords and the New York Accords. Oh, sorry, no, awards, not divided into 2, that is New York Awards, and the second one is Geneva Award. Okay? So, yaad rakhna that one thing which is very important for you to understand, that you don't have to study all these. This starts from section 44 and it goes to section 69, not 79, 69. Okay? Now, yaad rakhna that you don't need to study both of them. Domestic arbitration and international arbitration, you don't need to study both of them, because the domestic arbitration that we have, which is, well, what is the domestic arbitration? The place of arbitration is in India. The place of arbitration is in India. And here, the place of arbitration is a foreign country. is a foreign country. Right? So yaad rakhna ki even if the place of arbitration is India, or even if the place of arbitration is a foreign country, not much difference between the laws that are applicable upon that arbitration, right? Because the domestic arbitration is on par with international arbitration. Okay? So one thing which I always tell my students that अगर डोमेस्टिक आर्बिट्रेशन तुमने अच्छे से कर लिया, इंटरनेशनल अपने आप हो जाएगा. इंटरनेशनल आर्बिट्रेशन, because domestic arbitration has been designed in such a way that it almost resembles international arbitration. The making of the award, the enforcement of the award, which law, like procedural law, is going to apply or not, right? All of those things are, on what grounds the award is going to be set aside. All those things in domestic award are very similar to the international arbitration. There are many sections like section 9, 17, 44, 46, 47, 67, 53, 49. All these sections are similarly worded, right? In fact, in section 31 and 32, 34, there is the setting aside of arbitral award. It has the same grounds as in section 46 and 47, right? Almost दिखेगा same है. Section 8, 45 and 54. Let's take one example. एक example लेते हैं. If you are watching this lecture, go to section 8 and then section 45 and then to section 54. याद रखना, section 8 is for domestic arbitration. Section 45 is for New York awards and section 54 is for Geneva awards. If you go through the language of these sections, they are almost along the same lines. In fact, 45 and 54, they are exactly the same worded. Exact same words were used with. Section 8 is a bit different. I'm saying this again. Not exactly the same, but domestic award is on par with international arbitration. So, if you are thorough with domestic arbitration, आपका international अपने आप होता चला जाएगा. याद रखिए, there are corresponding sections. जैसे अब मैंने अभी एक कराया है कि अगर आपने domestic arbitration में you have studied section 8, your section 45 and section 54 are automatically done, right? So always keep this in mind कि you don't have to go through the entire act, especially in case of arbitration. You don't need to go through the entire act. You just need to focus upon domestic arbitration. अगर domestic अच्छे से कर लिया, international अपने आप हो जाएगा. That is the point I am trying to make. With these sections, we being the first of many examples कि there are corresponding sections of domestic arbitration in international arbitration. Not exactly the same, but they are along the same line. They are similar, but not the same, right? Now, देखो, for domestic arbitration, there are actually two ways that arbitration can be ordered, right? देखो, for parties to go through arbitration, there are two ways that parties can go to arbitration. One would be the parties enter into an agreement. First, right? Or the court may order that parties go for arbitration. Right? Now, yaad rakhna that this, where parties enter into an agreement that they are going to for arbitration for the dispute resolution, this is according to the Arbitration and Conciliation Act of 1996, right? The procedure for the agreement and what should be there in the agreement, what should not be there in the agreement, that is all given in Arbitration and Conciliation Act, right? Who can make the award? What are the what are the things that the arbitrator must have in order to become an arbitrator? Can he be removed? What is the procedure for his appointment? What happens when parties are at dispute with each other? That who is going to be the arbitrator? All those things are given in the Arbitration and Conciliation Act, right? When is the award going to be made? Is there a time limit within which the award should be made? Or what happens when the award is made and the other party one party wants to go for execution and the other party wants to set aside the award? What is the procedure then? So all these things are given in the Arbitration and Conciliation Act of 1996. But when the court orders that the parties go for arbitration, this is not provided for in the Arbitration and Conciliation Act. This is actually given under section 89 of CPC, that the court may order the parties to go for arbitration. But here you also need to be mindful of the fact that it is not that the parties are unwilling to go for arbitration and the court actually forces them to go for arbitration. No, that is not the case. Even here, the court may order that the parties to go for arbitration only when the parties file a joint affidavit. Only when the parties file a joint affidavit or their own consent memorandums or their own respective consent memorandums. Right? In this case, only when the court may order the parties to go for arbitration under section 89 of CPC, but only when the parties have filed a joint affidavit or their own respective consent memorandums that we are willing to go for arbitration. The court can encourage the parties, why don't you go for arbitration? Why are you trying to involve yourself in something which is going to take a long time? Right? The court can encourage, but ultimately it is the agreement between the parties or it is the joint consent of both the parties which is actually going to decide that the court will send them for arbitration or not, right? That is section 89 of CPC. Now, once the court has decided that an order will be issued for the parties to go to arbitration, what happens there is, after the court has ordered, let's say the court has ordered the parties to go for arbitration, right? Now here, after the court has ordered arbitration, again it is the Arbitration and Conciliation Act of 1996 that is going to apply. So ultimately we have to come to this act, right? So even in section 89 CPC, what happens when even the court orders that the parties must go for arbitration, there we cannot ignore the Arbitration and Conciliation Act of 1996. Ultimately it has to be this act under which the proceedings are going to be conducted, right? Now, so यहाँ पर देख लेना कि both these, the arbitration, the parties either they enter into an agreement and they go for arbitration, that is there is also a way, or the court may also order parties to go for arbitration, but here also the consent of the parties is still required. Without the consent of the parties, the court cannot send them for arbitration, right? And even eventually even the court order arbitration must be conducted in the manner given in the Arbitration and Conciliation Act of 1996, right? Now coming to the arbitration process, right? Dekho, in the act, that is the Arbitration and Conciliation Act of 1996, there are two methods of conducting an arbitration proceeding, right? Dekho, two methods which are like 90% same, but there is some difference. Only in the beginning there is a difference, but everything else remains the same. Okay. Now what is this? Dekho, there can be two ways in which the parties may enter into an agreement and go for arbitration. One is, one is where there is an existing dispute and the parties enter into an agreement to go for arbitration, right? Dispute पहले से था, and then the parties enter into an agreement that let's go for arbitration instead of going to the court. The second one is before the dispute has arisen. याद रखना, dispute अभी तक arise नहीं हुआ है, and still the parties contemplate a situation that what if a dispute arises, right? The parties contemplate a situation that what if a dispute arises. In that case, we should go for arbitration and we should not go to the ordinary civil court. The ordinary court procedure is not fit for the nature of dispute that is going to arise between the parties. So there is a future dispute. Sorry, there will be, not is, there will be. There will be a future dispute, and when that happens, we will go for arbitration. So even if even before the dispute has arisen, the parties, what do? They enter into an agreement ki if and when the dispute arises, we will not go for the ordinary court procedure, we are actually going to go for arbitration. So these are the two kinds of situations where the parties may enter into an agreement and then decide to go for arbitration. याद रखना, it is not that before the dispute the arbitration agreement must be entered into. ऐसा नहीं है बिल्कुल भी. देखो दोनों की टाइमलाइन समझना. The timeline for both the situations. First, where dispute is in existence, right? Now, let's start with here. Here, the dispute arises. Okay? Here, the parties enter into an arbitration agreement. Now, after the parties have entered into an arbitration agreement, the next step is the appointment of the arbitrator. Arbitrator. I am writing here is an arbitrator, but it can be an arbitral tribunal, more than one also. Sorry, arbitral tribunal. Okay. After the appointment of the arbitrator, first the parties the party which has initiated the dispute, right, or which has initiated the arbitration proceeding, that is to submit a statement of claim. This is known as a statement of claim. So the party which has initiated the arbitration procedure, first of all, that party is supposed to make a written submission to the arbitrator. So the statement of claim, that is called a statement of claim, and that is to be sent to the arbitrator. After the party who has initiated the arbitration proceeding, it has sent the statement of claim, the other party is supposed to make a statement of defense. Okay? Now, statement of claim is very similar to what we have in a civil suit, that is a plaint. This is effectively a plaint. Don't call it a plaint, and it has not been called a plaint in the Arbitration Act. It has always been called a statement of claim. Correct this. Statement of claim. Right? very similar to a plaint, and the statement of defense, this is very similar to a written statement. Okay. Now, after the written submissions of both the parties have been made, then comes the time for adjudication, right? So this timeline, I am extending it. This timeline is here. So here, let's say the adjudication is done, the proceeding is started, and the parties are called on upon to make oral submissions if the arbitrator needs. Arbitration thinks that there is a need for these oral submissions, and after the adjudication has been done, the proceedings come to an end by the making of an arbitral award, right? So this is like a civil case coming to an end with the judgment and the decree, right? Arbitral award marks the end of the arbitration proceeding. This is a general, I am saying this again, this is generally what happens, not necessarily कि यहीं पर हो जाए. Because after an arbitral award is passed, there are two courses of actions possible. The winning party would like to go for the implementation of the award, and the losing party would like to go for setting aside the award. Right? Now, these are the two courses of actions possible after the arbitral award has been passed, right? So you always need to keep this timeline in your mind while studying Arbitration Act. So this timeline पे actually the Arbitration Act has been designed in this way कि आपको इसी timeline पे वो सारा कुछ पढ़ना होता है. There will be sections here and there, but this is the basic timeline that you have to keep in mind while studying the Arbitration Act, right? But this was only one, right? हम लोगों ने देखा था कि there can be two ways in which the parties may go for arbitration. One is where the dispute is already in existence, the dispute arises, right? So when the parties enter into the arbitration agreement, the dispute was already in existence. Okay? Now, what if there was an agreement beforehand and the dispute arose later? What happens then? What is the timeline then? This was in the first case. Now, for the second case, the timeline is much similar, but there is only one significant difference, right? The second one, excuse me. The second one is, देखो यहाँ पर क्या हो रहा है? Here, the parties enter into an agreement. Okay? Now, after the parties enter into an agreement, and here in the agreement itself it is contemplated that what if there is a dispute between us? What do? We will not go to the ordinary civil court. What we are going to do? We are going to for an arbitration, and here the dispute arises. Okay? Now, because there was already an agreement and the dispute has now arisen, what is now going to happen? It is immediately going to start whatever we have done before, that an arbitrator is appointed, right? Much like before, the arbitrator is appointed. After the arbitrator is appointed, there must be a statement of claim submitted by the party who has initiated the arbitration proceeding, and after the statement of claim has been made, the other party is going to make a statement of defense, right? So as before, statement of claim is much similar to a plaint, and statement of defense is much similar to a written statement, that is the WS. And after this, the statement of defense, when the arbitrator has both of them, then the arbitration proceedings, the adjudication is going to start, and there what is going to happen? The adjudication will start, and the adjudication is going to end with an award and after the arbitral award has been made, this is the arbitral award which is made, and after the arbitral award, same thing, there are two courses of action possible, that is implementation, also known as execution of the award. This is the execution of the award, and the other party would like to go for setting aside the award. Right? So you can see there are almost almost on the similar lines. The only difference is here that before the dispute has arisen, the parties have entered into an agreement that what we need to do, we have to contemplate, or we have to actually anticipate that a dispute may arise. That is, and when that arises, it's not, we are not going to the ordinary civil court. We are actually going to go into the arbitration, because that is what we agreed to, right? So the only difference between the two timelines is the first two steps, right? ये flip कर जाते हैं. Everything else remains the same. Only these 2 points are going to differ and not anything else, right? So on this timeline, the entire Arbitration Act can be studied, right? इसी timeline पे पूरा Arbitration Act आपका पढ़ा जा सकता है. So that was to give you just an overview what an Arbitration Act is, and what is the need for ADR, what is ADR, and how many types of ADR there are, and the Arbitration and Conciliation Act, what does it contain, and how it should be studied. So it should be studied in this timeline, and whenever this timeline, just always keep this in mind, because it is a step-by-step procedure, right? अगर आपको ये step, or if you remember this timeline, it will be very easy for you. It's not like you are not going to understand Arbitration Act. You will still be able to grasp it, but this will be much more convenient way of studying the Arbitration Act. That is all. That is the only point I am trying to make, right? Okay. So that will be it for today's lecture, and we will continue in the next lecture.